This is what the Sherman Antitrust Act is and how it has affected American businesses throughout history. We have used cases over the years since its creation to explore the interpretation and what that could mean for big tech companies in the future. The Sherman Antitrust Act was put into place in 1890 to protect consumers from high prices and predatory monopolies. It also protects the market and allows new businesses to thrive without impossible competition.
A monopoly is a single establishment selling a one-of-a-kind product or service, while contending with no opposition in the market, vying for the same clients. Monopolies will utilize unreasonable operations such as governmental licensing, expensive starting costs for other organizations, setting exorbitant prices for buyers on basic items, control over limited resources, and copyright and patents to further their grip on designs and innovations. These measures will starve out other rival companies, damage a free market, and may impair coming innovations that would better serve many in the future.
Through examining the ways in which legal interpretations of the Sherman Act have changed over the course of its history will allow clear understanding of the development of American businesses. This will also provide insight into the ways in which antitrust laws may evolve to meet the demands of the modern digital economy.
The origins of the Sherman Act are closely tied to the rise of industrial monopolists in the decades following the conclusion of the American Civil War. During this post-war period, many large industrial firms came to dominate vast swaths of the economy, from transportation to manufacturing and resource extraction. While some of these monopolies were the result of a firm outcompeting its competitors, many others were created through anti-competitive, exclusionary practices, such as horizontal mergers and the formation of price-fixing cartels. To address these companies' growing stranglehold on the economy, it was decided that comprehensive federal action was needed, and that action came in the form of the Sherman Antitrust Act, which was signed into law on July 2, 1890, with the near-unanimous approval of Congress. The act was designed to protect competition against monopolistic practices, and has formed the cornerstone of U.S. antitrust legislation ever since.
In 1892, the E.C. Knight Company operated 98% of the sugar trade in the United States. After their long reach became apparent in this trade, the president of that era, Cleveland, insisted an intervention within the scope of the Sherman Act. Despite his urging and conclusion of the trial, it was decided the E.C. Knight Company's actions did not merit interference. After an 8-1 vote, the trial was dismissed, and the E.C. Knight Company was excused because the manufacturing was on a local level. A man by the name of John D. Rockefeller led a company called the Standard Oil Company located in the United States. By 1880, through elimination of competitors, mergers with other firms, Rockefeller controlled the refining of 90 to 95% of all oil produced in the United States. Many Standard Oil critics believed that the resulting concentration of economic power for one company was becoming excessive. In 1906, the United States federal government took action against the Standard Oil Company and brought them to the New Jersey Supreme Court for violating the Sherman Antitrust Act of 1890. It was ruled in favor of the government's claims, and the Standard Oil Company was broken up into 34 smaller, individually owned companies. This ruling was a huge win for the federal government in the fight against monopolies, as this case set the foundation for future antitrust hearings.
Large corporations such as Verizon, Microsoft, and Apple are technology giants running unregulated, with citizens blindly putting trust within the companies. The federal government is aware of the changes and understand that changes must be made to regulate these companies within society. The Sherman Act allows the United States to have proper competition throughout the market, as well as protect the safety of consumers.
The past 20 years have seen a number of landmark cases that have helped to define the Sherman Act in the digital age. Perhaps the most famous of these cases is United States versus Microsoft Corporation. which was one of the first major antitrust suits brought against a technology company and centered around allegations that Microsoft had violated the Sherman Act by bundling its Internet Explorer browser with Windows operating system. Though the courts ruled against Microsoft and initially ordered its breakup, the corporation successfully appealed and got the order to divest overturned, as it would ultimately harm consumers by making the company less efficient.
Technology and the internet are quickly turning into the largest and most complex corporations and are run by the world's brightest. They have very little competition because the technological advances are complex and hard to execute. Concerns such as these can cause issues for the big tech corporations in relation to the Federal Trade Commission, as well as certain antitrust laws. The federal government is playing catch-up with the big tech industry. They will need time to recover in order to protect consumers, as well as safeguard against the monopolies that may originate from big tech. Few pieces of legislation can rival the kind of enduring impact on the American economy and social fabric that the Sherman Act has had. Since its formation in the wake of the industrial monopolies that dominated turn-of-the-century American society, the Act has experienced numerous evolutions and formed the core of U.S. antitrust law for the past 130 years.